Welcome to my channel. Please like, comment, and subscribe. Limitation of Liability Act of 1851. Injured on an offshore vessel will represent injured workers nationwide. Maritime law states that the owner of a vessel may be liable for any losses or damages that happen during the voyage. However, many ships' owners attempt to avoid responsibility for accidents and death that occur on the vessel under the Limitation of Liability Act. This allows owner, in certain cases, to limit liability if the unseaworthiness condition of the vessel causing the loss occurred without the knowledge of the owner. The Act covers personal injury losses such as death and collisions, as well as cargo losses like loss of property, goods, or merchandise. Injured seamen soon realizes the importance that this Act plays in determining the amount and availability of compensation available, because the liability is limited to the value of the vessel and its freight then pending after the time the loss occurred. This may mean that an injured offshore worker, will not be fully covered in the claims for damages. For this reason, the Act has been increasingly criticized for being obsolete in the face of newer methods that make it easier to invest in maritime commerce without the fear of unlimited liability. Regardless, the Act still plays a dominating role in determining the amount of compensation that an offshore worker can receive. Why does the Limitation of Liability Act exist? The Limitation of Liability Act was initially created to protect ships' owners from financial ruin. The Act was fashioned in a historical period where the shipping and maritime industries were much riskier than they are today, as it faced catastrophes like unpredictable weather periods, attacked by foreign nations, fatal illness, and other serious hazards at sea. Legislators feared that lawsuits from injured crew or absent merchants would hamstring the American shipbuilding and shipping industries. To mitigate the high risk shippers and ship owners faced on every voyage, the Limitation of Liability Act created under the Limitation of Liability Act, a ship owner will be able to limit their total financial liability to the value of their ship if a say crew needed to offload cargo during a storm in order to save themselves. The merchant who owned that cargo would only be able to sue the ship owner up to the total value of the ship. Keep in mind that in 1851, a ship owner had no way of communicating with his vessel or captain. Whatever happened at sea was ultimately not the owner's fault. It protected shippers, made international trade more profitable and less risky, and ultimately helped America prosper and grow. However, in recent decades, the law has been used in a way totally unintended by its author, protecting large corporations from being held accountable for their negligence. See, in 1851, the American maritime landscape did not have the resources we have today. They did not have weather forecast equipment. We do. They did not have satellite GPS. We do. They do not have long-range communication equipment that keeps ship owners in contact with their vessel at all times. We do. With all of these resources in place, the only disasters that take place at sea are ones caused by a gross negligence or poor safety practices on the part of the owner. Modern uses of the Limitation of Liability Act of 1851. In October 2015, TOTE Maritime vessel Elvarus steams right into a hurricane despite having a history of engine failure. As a result, the ship sank and all 33 crew members were killed. Recorded conversation between the captain and TOTE Maritime revealed that the captain had wanted to go around the storm on a slower route, but investigators questioned whether TOTE had pressured the captain into taking the faster, more dangerous route. Other records show that TOTE's vessel had a history of sudden power loss, and the El Faro in particular had 23 documented deficiencies with the U.S. Coast Guard. Experts believe the El Faro lost power in the middle of the hurricane, which eventually destroyed the ship. Shortly after the news broke that the El Faro was gone, TOTE Maritime quickly filed a lawsuit under the Limitation of Liability Act of 1851. Filing for protection under limited liability was essentially their way of saying they were not going to attempt to make things right with the spouses and children left behind by their negligence. It was also their way of forcing every grieving family member to either bring their case to court immediately or waive their right to bring it at all. While TOTE was insisting that their ships was only worth a small amount, thus limiting each family's total potential compensation to pittance. They filed an insurance claim with the insurer for the ship. The value they claimed in their own insurance filing was higher than the value they claimed under the Limitation of Liability Act. In a sense, they were hoping to profit from the destruction of their own vessel, and the loss of 33 lives. Each person's life was worth far more than their vessel, but that did not matter. That's what the Limitation of Liability Act of 1851 does today. It reduces a person's life to a fraction to the value of a sunken ship. Through Aquatics, the Limitation of Liability Act, and the 2019 California boat fire in perhaps one of the most egregious misuse of the Limitation of Liability Act. A company called Truth Aquatics sued their own surviving crew and the families of 34 victims after a California dive boat fire left dozens dead. In September 2019, a dive boat named the Conception was doing a tour off the coast of Santa Cruz Island when it caught fire early Labor Day morning. The captain and 4 crew members attempted to rescue the 34 people sleeping below decks, but the fire kept them from getting to them. In recorded call between the Coast Guard and the crew, the Coast Guard asked if there were fire extinguisher aboard, but there is no audible answer. The remains of 2005 people were found the next day, and the remaining 9 passengers were presumed dead. Truth Aquatics Inc. filed a limited liability claim just 4 days after the tragic loss of 34 lives and the injury of 2 crew members, forcing dozens of grieving people to hire lawyers when they should have been mourning. How is the Limitation of Liability Act misused by vessel owners? The Limitation of Liability Act was enacted nearly 170 years ago. At that time, the hazards of maritime trade were too extreme. Vessel owners needed protection, and this came in form of limitation on liability to the value of their ship. Today, maritime hazards are still present, but we have the tools and resources to mitigate them. Instead of using the Limitation of Liability Act for its intended purpose, some vessel owners are using it to limit injured seamen's valid claims. They are trying to shirk their responsibility to the hardworking people on their vessel. How can I challenge the Limitation of Liability Act? Even when a large corporation tries to defend their interests under the Limitation of Liability Act, a skilled attorney can challenge this defense and see justice served. It is precisely what we at Arnold and Aitken have done time and time again. We have successfully fought the limited liability defense in notable cases, such as the Deepwater Horizon explosion, the sinking of El Faro, and many others. Our attorneys fight unethical and immoral practices by large corporations to seek accountability, answers, and justice. I think that's all guys information that I can say to you. Thanks so much guys for watching, and if you guys need information related to maritime topics, you are in the right channel, because in this channel we talk about it a lot guys. Thank you so much guys for watching. I hope you like the video that I've said to you. Don't forget to give like, comment, and subscribe. Bye bye guys, see you in another video.